on soft copy. And Your Honor, they are of 400. We will need time to prepare our defense and be able to compare the photographs with the other forensic materials they have given us, which are equally bulky, running to almost 1,000 pages. Accused persons, so we'll need at least 2 months to prepare our defense. We therefore request for a further date. The documents have been given on very short notice. That is all, Your Honor. Accused person, and a warrant of arrest has been issued against him. Yes, and it has not been, the IO has not given for all of them. Yeah, for all of them.
Your Honor, the issue, the reason, Your Honor, that has been availed that they need more time to review other things, like further to review the photographs. You know, we documents were, I mean, the photographs were in black and white, and the defense thought that we now supply colored copies, which has been done. Them to have the last time it was the IO had indicated that we supply immediately. And it has been delayed at the instance of the defense. And pray that the court allows us to proceed in the interest of justice.
What speaks for itself. Your Honor, further, Article 50, sub-Article 2 and Part C gives the accused persons the right to have adequate time to prepare for their defense. Your Honor, adequate time to prepare for defense is then determined by the defense. It is not for the prosecution to give us documents only 2 days to the hearing and then tell us that is adequate time. As the defense, we have the right to indicate to court the time we need to prepare for our defense. And Your Honor, the photograph is not just a question of looking at the photographs, which, as I have said, there are about 500 photographs. And that is why we had wanted the photographs in color, because the ones that were given in black and white were not clear photographs, and therefore they were not assisting us in preparing our defense. We need to compare these photographs with the other evidence the prosecution has provided and we need to discuss that evidence with each accused person. As much as they are charged together in one case, Your Honor, the court in due course will look at the witness statement, and it is the prosecution's case that each accused person played a different role in this case. So each accused person, based on the charge against them. And that is why we will need this time. It is not for the purposes of delaying the process or just simply adjourning. So as we have indicated, we need at least 60 days, given that December, the month of December, law firms are also closed. Like we'll be closing from 10th of December and resuming in 5th of January. Your Honor, advocates are also entitled to leave, annual leave. And this is why I've requested for the 60 days, taking also the December holiday into account. It will be difficult for us to get other councils present to be able to convene meetings with our clients. So, Your Honor, in the spirit of the purposive interpretation of the Constitution, under Article 260 of the Constitution, we pray that you allow us adequate time to prepare for the defense and adjourn this matter. Case of their own choice. I would have informed Ms. Amolo to be in court in a good time, but because the file was not found, I informed them we are not partisan.
Also put in a brief agenda. First and foremost, I entirely associate myself with the sentiments of the week. Secondly, Your Honor, the last time we were before you on the 2nd of September, the investigating officer was to supply us with a soft copy of the photographs before close of business that day. And the investigating officer confirmed that he would indeed supply the photographs. We are not being told why the investigating officer has waited for a period of over 2 months to supply us with the photographs 2 days before the hearing. Your Honor, such an action would amount to trial by ambush. As we have been told by the High Court, the witnesses the prosecution intends to call today are scene of crime officers who shall be coming to produce the said photographs. It will be prejudicial to our clients if we were to proceed with the hearing for productions of photographs that we have not had a chance to examine. Your Honor, in the interest of justice, we urge the court to find that an application for adjournment is warranted and to indulge us and give us another day.
Your Honor, if
I should point out to the court that one of my witnesses is one Kennedy Akula, who is a retired Kenya prisons.
Kennedy?
Kennedy Akula. Kennedy Akula Aluda. Kennedy Akala. Sorry, Kennedy Akala Aluda.
Aluda.
Aluda. Who is a retired Kenya Prison Services officer, and who has, rather has traveled all the way from West. He's also present in Rotterdam as one of our officers.
So what is your
It's legal, and maybe
when we have not appreciated the case against the accused persons as a whole, and to also have the theory of our defense, which is what we will be trying to prove in court. So during a trial, when we are not fully prepared, is prejudicial to our clients and we pray that the court adjourns the case. It is not our fault, really, because the IO had agreed to give us everything on 2nd of September. So that is over 2 months, almost 2 months down the line. And they were in soft copy. He's only giving us the documents 2 days ago. And if I may add, at around 5 p.m. So that only left us with 1 day to prepare. So, Your Honor, this then would not amount to a fair trial as enshrined in Article 50. The court has a recourse to refund witnesses their transport. So I believe the court can direct that the witness be refunded his transport. It is unfortunate that the mishap has been occasioned by the prosecution, and the accused persons ought not to suffer because of the IO's laxity to comply with court orders, for which he has not even given any reason.
These persons through counsel have sought an adjournment on the grounds that they were supplied with over 500 photographs 2 days ago, and that they need adequate time to prepare for the same. The prosecution indicated that they had another witness who will not touch on the issue of the photographs. Counsel for the defense, accused persons, submitted that it will be prejudicial for them to proceed with the witness, and they have not been able to analyze the photographs supplied to them 2 days ago. The prosecution has conceded that indeed it's true the said photographs were supplied 2 days ago. The defense counsel submitted that they were supplied with 500 photographs 2 days ago, and they needed time to prepare for the same. Article 52C of the Constitution provides that, and I quote, "Every accused person has the right to a fair trial, which includes the right to have adequate time and facilities to prepare a defense." In addition, Article 25C of the Constitution provides that, and I'll quote, "Despite any other provision in this Constitution, the following rights and fundamental freedoms shall not be limited." C, that is the right to a fair trial. In other words, the right to a fair trial is non-derogable. The prosecution, having supplied over 500 photographs to the accused persons 2 days ago, cannot be said to be in tandem with the provisions of Article 52C of the Constitution that the accused persons ought to have adequate time and facilities to prepare a defense. The upshot is that I hereby allow the application by the accused persons for an adjournment, and in addition, the witness, Kennedy Akola Aluda, will be reimbursed his travel expenses. Those are the
in previous occasions, just after the court file went missing. So we urge the court to inform the media that the order of Honorable Kimilu is still in force. Should they publish this matter and their publication be prejudicial to our clients, we will take the necessary steps to sue the media houses and the journalists who were before this court in person, because they were warned by Honorable Kimilu. So, Your Honor, that is my prayer that be maintained. And we also pray that the file be maintained to be under key and lock. We pray that the order be signed today so that the vehicle can be released. This can, as assist in keeping the file in safe custody.
Prosecution.
Ms. Yona, I believe the issues that have been
We had indicated to the court that he had a mental issue. And the court directed and issued also warrants of arrest to the IO to verify his status and if necessary also arrest him. The IO has not given any report whether he has even gone there, found that he was sick or not. So Your Honor, at this stage, it would be unjust to forfeit the cash bail before.
Colleague, Honorable Kimilo, ordered the file be placed in safe custody.
Yes,
Okay.
that was last year.
Last year.
Yes.
Just safe
Before-
custody.
In fact, before the files were consolidated
Okay.
and before the first accused even took plea.
Just that, safe custody only.
Yes, safe custody, but she also warned the media not to publish the personal information about our client because we had to produce his medical documents and history which are in the file.
When was that? So that I can check.
I think it was-
Are they barred from reporting or because of the the health issue?
Yes, because of the
Health
because of
only.
the health issue, yes.
Not any other thing.
No, because of the health issue.
I can also look at the record.
Remember the exact date when you look at the proceedings.
That's why I'm asking you to assist me. When? The arrests will remain in force against the sixth accused person. Cash bail is hereby forfeited in respect to the sixth accused person, and the file to remain in safe custody. On the other issue, counsel, that you are raising, I'll urge you to file a formal application. Mention, can fix it for a mention. Number? Yes. Second, it's convenient?
Second of December.
Yes.
Yes, it is convenient.
Okay.
Your Honor, since it is to confirm for future, is the difference with the sixth accused. Is it possible for the other accused person to not attend?
I think
Must they all come?
just let them come so that because I'll give also a hearing date. That's it. Anyone for judgment? Anyone for judgment?